Good evening, I'm Jeff Bartlett. Welcome to Ask the Specialist. Tonight, we'll ask the estate planners here on CMU Public Television.
Support comes from Smart Investing at Your Library, a partnership between the Genesee District Library, FINRA Investor Education Foundation, and the American Library Association. The mission is to provide the public with knowledge, skills, and tools necessary for financial success throughout life. More information online at thegdl.org's Dollars and Cents Cafe.
Good evening, welcome back. Tonight's show deals with estate planning, elder law issues, charitable giving tax issues, those sorts of questions. If you have those questions, we'd like to hear from you. 1-800-727-9268, the number to call to ask those questions. Joining us tonight is Doug Chalgian of Chalgian Tripp Law Offices in Lansing, Battle Creek, Jackson, and Ithaca. Doug, welcome. Thanks for joining us tonight.
Thanks, Jeff.
Why don't you give us a little bit of background?
I'm a lawyer. And as you indicated, we have several offices, and our firm does only estate planning and elder law probate work.
Okay, great. So hopefully we'll have a couple questions you might be able to answer.
Hopefully that's why I'm here, yep.
Great. Also joining us tonight is Randy Dickinson of Isabella Bank and Trust. Welcome, Randy. Both of you returning, so appreciate you joining us again tonight.
Thanks, Jeff.
Randy, give us a little bit background of your specialty.
Okay, real quickly on Isabella Bank and then myself. Isabella Bank is centrally located here in Mount Pleasant, Michigan. We serve about, we have 26 branches within the Mount Pleasant, mid-Michigan area, serving 7 counties. Myself, I've been with the bank for 20 years now. Certified public accountant, certified trust financial advisor, belong to different estate planning groups. So I've been in the administration area for quite some time. We don't draft trust. We have the attorneys draft the documents, but the bank will act as the trustee or the person representative, the administrator of the estate.
Okay, great.
So thank you.
Well, thanks for joining us again tonight. Estate planning, what do we mean when we say the term estate planning, Doug?
I always say estate planning is about 2 things. What happens to your stuff when you die, and who makes decisions for you during your life if you're unable to make decisions for yourself. So that incorporates wills and trusts, powers of attorney, medical directives, those types of documents. So putting together the documents that establish a plan for your estate, and sometimes I think the word estate probably limits what people understand about what the process is. It's more than just what happens when I die. It is inclusive of planning for the management of your assets and your well-being during your life as well.
And elder law, that's a term that you also mentioned, and how does that differ from the estate planning?
You know, in the minds of the public, I don't think there's a great distinction. And elder law is sort of a newer term that has evolved in the last 10, 15 years. Generally, it is associated with more issues related to the aging process. So more guardianships, more government benefits, Medicaid eligibility. But an elder law practice is comprehensive in terms of it also deals, you also prepare wills and trusts and powers of attorney in that context as well. Probably elder law is a little broader field.
Okay, great. We were talking before we got on camera about some of the changes that have taken place in tax law with the most recent fiscal cliff issues. Why don't, can one of you maybe give just a real quick overview of those changes and how it might affect folks who are thinking about estate planning right now?
Well, I'll hit on a couple of them. One of the things that we weren't sure what was going to happen had to do with the estate tax. It was going to revert to $1 million. So if you passed away and your estate was greater than $1 million, the way it was under the law back in 2012, going into 2013, you were going to be subject to a federal estate tax. They've now made that, right now it's $5,250,000, and it's indexed for inflation. So now there's a lot of people that will not have to worry about ever having to pay any estate tax, if they're less than that dollar amount, and also an inheritance tax. Michigan does not have an inheritance tax, and they haven't had one. So that's one big thing. The other thing is, of course, the gifts have been indexed as well throughout the years, and we're now at $14,000. So those two, plus the portability feature, that's now permanent. So we have portability where if you don't use your $5 million exemption, it's portable, and your spouse can take advantage of that $5 million and get up to, right now, it'd be $10,500,000. Okay. So I think those are two of the big, well, the estate tax and the portability are certainly two big aspects that have happened.
Okay.
Yeah, I agree with Randy. I mean, the significance of that decision by Congress to permanently fix the estate tax at a very relatively high figure, $5 million per person, really changes the place of estate planning for people. And I think it puts a period on the end of what has been a long stretch of years in which there's been uncertainty about what's going to happen with the federal estate tax. Now that we know, now that it's permanent, that there will be a $5.25 now million exemption per person. Sort of this long history of people using trust agreements as a means of exercising their maximum death tax credits is pretty much over. I mean, there will be people who have estates beyond $5 or $10 million if they're married. But for the vast majority of people in Michigan and people who do planning, their estate plan, their trust, or whatever document they elect to use isn't going to be driven by this need to address the federal estate tax concerns, which has historically been a large part of what estate planning has focused on.
Okay. Question from Charlevoix. Question is pretty simple. Should he set up a trust? His estate is worth about $350,000, and his brother said it should be at least $1 million. So should he do it? And if he does setting up a trust void the need to go to probate?
Well, I could take that one, I guess. You know, the question is whether you need a trust or don't need a trust. It really depends on what your plan is, your estate plan. What do you want to have happen? If you have a trust, you can, if you fund it properly, you can avoid probate. So there certainly are, if you want to avoid probate, you can have a trust, fund the trust, and if everything's in the trust, you can avoid probate. If you forget to put something in the trust during your lifetime, and you may end up still going through the probate process. Okay, so that'd be called a pour-over will, where you would pour over the assets from your estate into your trust. So the question becomes, should you have a trust? Should you not have a trust? Is it really based on everybody's circumstances? There could be somebody that has $100,000, $50,000, but they don't want somebody to receive it immediately upon their death. They want them to receive it over a period of time. Well, you could certainly accomplish that with a trust if you wanted to. Okay. So a trust provides more flexibility than a simple will would have. And that's why I get back to what assets do you own? What are you trying to accomplish? Good.
Doug, anything?
I agree with everything
that
Randy said. It's not a number issue. It's not 350,000. It's about are there other things that you're trying to accomplish with your estate plan than divide by 2 or divide by 4?
Okay. Call from Traverse City. What is a ladybird deed, and how common is it in Michigan?
I can jump on that. A ladybird deed is a fairly new development, and it functions like a beneficiary designation on real estate is the best way to describe it. So you say, during my life, it's my, and it deals, we talk about deeds, we're talking about real estate, homes, farms, cottages, those types of things. So you're talking about a document that allows you to keep your property during your life and to sell the property and to mortgage the property. But if you haven't otherwise conveyed the property at your death, it sets up a beneficiary arrangement on it at death. Are they common? They're very common, becoming more common. I think at times they're overused because they do some simple things well, but they are not an answer to everything. And I think a lot of time with a lot of things that come up, it's a new thing, people like it, it seems simple, but it doesn't anticipate everything. They are most popular and probably most beneficial in the context of Medicaid eligibility, people who are receiving particularly nursing home assistance through Medicaid. Then they serve a particular function of avoiding what's called a state recovery, which is a ability of the state to come back and make a claim for medical care costs.
Okay. An email from Livonia. Should IRAs and 401ks be included in trusts? And is the answer a personal preference, or is it governed by legal or IRS requirements? Randy?
Well, again, when it comes to IRAs or other types of retirement plans, you can name a trust as a beneficiary, and you can certainly name individuals as beneficiaries. So it kind of gets back to the estate plan. If you want the assets to go outright to the beneficiaries, you know, there are some advantages of possibly just naming the individuals as the beneficiaries of your IRA or retirement plan. But you may have other provisions in there where they're not outright distributions going to be given to the beneficiaries. And if that's the case, then you may go through with the trust and have the trust be the recipient of those assets, and then the trust can pass those on to the beneficiaries. So you really have to analyze the situation, because there's differences between naming a trust as a beneficiary and what we can and cannot do versus naming individuals as beneficiaries. So it's really something that it's all part of your estate plan. That's an asset of your estate, along with all your assets you have and what your plan is with your trust or your will. You have to look at everything and then make a determination what makes the most sense based on who my beneficiaries are and what my estate plan is.
Okay. Call from Eversprings. If they own property out of state and the children live out of state, do they need a lawyer here or out of state? They have a trust, so I'm guessing perhaps, well, I don't want to make assumptions on that. So anyway, where do they best need to have the lawyer, and should children be the co-owners of the property?
I'll answer. I think you got two questions there. One is, it's most appropriate to have a lawyer in the state in which you reside prepare your estate plan, because that elects state laws that apply, and it's your residence that's primarily going to control that. It's very common for trusts to own property from other states, and in fact, when we talk about whether you need a trust, having property in multiple jurisdictions is a good reason at times to use a trust. In terms of putting your kids on the title of property, I generally, you know, these questions I'm answering with very little information, right. But as a general rule, that's not the best way to pass a state through joint ownership. There are exceptions to that, but as a general rule, don't put your kids on as joint owners. Use a appropriate estate planning document, such as a trust, to accomplish your objectives. Okay.
Well, what about grandchildren? This question coming from Schwartz Creek.
Same. Well, we've been all over the state already, from Traverse City to Livonia to Schwartz Creek. Good.
The question is, how should the state be set up for grandchildren not seen in 15 years who live in California, while including grandchildren that are close?
Yeah, well, that's a good example of what Randy's talking about. Well, what is your objective? You know, there is no law that says everybody is equal by, you know, some bloodline. If you have a relationship with grandchildren that are close to you, and you want to see that your trust or your estate plan gets them through college, and you feel less connected and less dear towards children who you haven't seen grandchildren you haven't seen in 15 years, there's no requirement that the grandkids in California get the same amount as the grandkids in Michigan, and that's something that you, as the person who worked and saved and established this estate, need to decide. Totally personal preference, and I think a lot of people do fall into the everything has to be equal rule, which if that's how you feel, then that's how you feel. But you have to understand there's no obligation along that line.
Yeah. Flip side to the question here. How do you find out if you're in someone's will when they die?
You have to get notice.
You have to get notice.
Yeah.
And where does that come from? The attorney that's handling the will?
If there's an attorney
the probate
involved,
court,
it would be the fiduciary, if it's the bank, and I'll let Randy talk to this, it often is. The bank is the trustee or the executor of the estate. They know what the law is, and they know who they have to notify regarding their interest in anything.
Yeah, and that's the same with if you're probating an estate or if there's a trust, because a trust is going to be between the fiduciary, the trustee, and the beneficiaries. I mean, the courts aren't going to be involved, and so it's going to be a pretty private affair between trustee and beneficiary. So it's important that the trustee, who you were selecting, again, the bank does act in that capacity, that trustee is providing the proper information that they're required by law to the beneficiaries.
Okay. We're in farm country around here. Question about a farm. Farmer's approaching retirement age, and he asks, what should he be doing, and does he need long-term care insurance? Again, two questions. Not sure what the circumstances are, but maybe you can provide a little context.
Yeah, I'll try and hit it first and let Randy jump in. You know, farms are, like a lot of assets, unique. They're unique in a couple different ways. They represent typically some sort of long history in the family, and they're also a business. It is not uncommon in family farm situations to have one or more of the children who now stayed on the farm, and I've worked on the farm, and often when you're working with farmers to do planning, there's a desire to create an estate plan that allows that child or those children who remained on the farm and to continue to work the farm to be able to purchase the property from the other children, or to simply receive the property, because a lot of farmers will say, well, I'm not concerned about equality here, because in my mind this child who's been farming on the tractor with me every summer has already earned this, and it really is their farm. I just need to make sure it gets to them. Farm land is been particularly valuable, and the value of farmland has risen dramatically in Michigan in the last several years. So there are tax issues associated with that, capital gains issues. So many of the farmers who have farmed their whole life bought this land for $1,000 an acre. Now they're selling it for $7,000, $8,000, even $10,000 an acre. So you've got some real tax issues that you want to make sure are thought through in that process. On the second question, and this is certainly not limited to farmers, long-term care insurance is an insurance which can pay for the care costs if you get to the point where you are unable to care for yourself. Is it good? It's great. It is not inexpensive, so you have to be realistic about that, and you have to understand how to shop for a long-term care policy. But at the end of the day, in this age that we live in, where living to be 100 years old is not an uncommon thing, people need to think about, there may be 10, 20 years of my life in which I'm unable to really take care of myself. And what you see is people who have resources are able to provide themselves with some level of quality of care during that could be lengthy period of impairment. And money in that context is what's going to give you quality of care. And long-term care insurance can be an important source of the funds to pay for the quality of your care as you age. Okay. Did you want to add anything to that?
The only thing I guess I would add is whether it's real estate, and we're talking about a farmer in this instance, but real estate or any other valuable type of asset that you might have, whether it's a cottage, whether it's your business. And the idea is, how do I distribute this to the beneficiaries and try to, when I have a valuable asset that maybe can't be divided because I want to give that to a particular person. Again, some people have bought life insurance in the past to make up for that difference. Upon their death, there'd be some cash coming in so they can help with that equalization. And at certain times, you may end up giving one of the beneficiaries that particular asset at a discounted price so they can actually afford to have it or to buy it from the others. So that's one way of trying to keep it in the family.
Okay. What's the amount of tax on an estate or a trust after a parent's death?
Well, you know, when we talk tax, we're talking, are we talking estate tax or are we talking income tax? Because if we're talking about estate tax, whether you'll have to pay any money on the value of your estate, it's up to $5,250,000 right now. So if you're less than that, you don't have to worry about estate taxes. The question now is, do I have to worry about income taxes? Well, what's going to happen is from January 1st through the date that your surviving parent passed away, that income will be paid on the parent's final tax return. So if they pass away in September, January, September, on the parent's return will be that income. Any income earned after that period of time would be shared, if it's going through an estate or a trust, would be shared by the beneficiaries. So if you were cashing in IRAs, or there's some annuities, or there was some type of deferred income that was now going to be recognized, that income would be shared with the beneficiaries. If you didn't have those types of assets, if you had savings accounts or stocks or different types of investments, there may or may not be any type of income tax consequences associated with that. So it depends on the nature of your assets. So you got to remember, it's estate taxes. Do we have a problem there? Most people will not. And then we have income tax issues.
Okay. Interesting question coming from Troy. Must relatives that are not beneficiaries in a will be notified of the death?
No. Well, if they're heirs at law, they would be.
And define heirs at law.
It would typically be the people who are your descendants, that is children and grandchildren. If you didn't have any descendants, if you didn't have any children, then it would be siblings or even parents.
Okay. If you have an adult...
And I want to say that's a will.
That's
That's
a
a
will.
will, that requirement. The trust, not so much. Trust is more, and one of the advantages of trust is you control people who are the beneficiaries and therefore the people who are entitled to notice.
Okay.
Right.
Call from Everett. If you have an adult daughter and you want to make sure that she gets everything and that her husband does not, how do you do that?
You know, I've heard this a few times. Not happy with the son-in-law, maybe not happy with the daughter-in-law. First of all, what happens is in your estate plan, you could name your daughter as the beneficiary. If your daughter predeceases you, you could name the children, if there are children of your daughter, to receive those assets. But you certainly do not have to name the son-in-law. Now, you got to remember, if you give that outright distribution to the daughter, then in essence, if you know, that may be shared with your son-in-law. So you can certainly eliminate your son-in-law from receiving from your trust or from your estate. Now, the second thing would be is if that's a concern of yours, maybe you're not going to give an outright distribution to your daughter-in-law or your daughter. Maybe you're going to have the trust provide for your daughter throughout her lifetime, but it may never be fully distributed to her. So the trustee can take care of your daughter, but upon your daughter's passing, it would go to whoever you want it to go to.
Okay. Caller has a question about gold coins that he or she has in their trust and wants to know, when the trust expires, what's the best option for the gold coins? This person's been saving them for 30 years. Doug?
Well, they're part of your estate, so you're going to have to decide who receives your estate. Typically, the fiduciary, if you've left it in trust, to continue in trust, or if you're distributing it outright to your beneficiaries, it's going to be up to them whether they retain the asset in its present form or sell the asset and diversify it. With assets, and the gold is a good example because it's appreciated in value a great deal since he bought it 30 years ago. The good news is the capital gains associated with that asset is going to be forgiven at his death, so long as it's included in his estate, so that it can be sold at his death by either the fiduciary or by the children without any realization of a capital gains tax at that time. And then diversified is typically what would happen at that. You know, for instance, the bank would be, if the bank were the fiduciary of that trust, they would be, unless the trust specifically instructed them to hold an asset like that, they would typically be required to sell it and diversify, so that if gold goes down 30% next year, you know, the beneficiaries aren't harmed by that.
Yeah. If it was going to be an outright distribution, what we'll often do is we'll meet with the beneficiaries to see if there's an interest in any of the beneficiaries receiving that particular coin, and then, of course, place a value on it. And maybe we can get some agreement among the beneficiaries who's going to receive what.
Okay. How often should an estate be reviewed?
Go ahead.
Well, when we're named as successor trustee, I like to have people come in and visit with me if there's been any significant changes, and significant changes could be a marriage, divorce, new children, what have you, or different types of investments they've made. But every couple of years, I'd like to have them come into the bank and review the trust document, review their assets, just to see where they're at. Laws change, their circumstances change. Every couple of years, unless something significant has happened, then more frequently, but every couple of years I would like to go over that with them. Okay. I don't know, Doug?
I agree that it's more about changes. It's more about changes in circumstances in the law are important reasons to get things updated.
Short of doing nothing, what's one of the worst things you could do in structuring your estate plan?
Huh. That's a really good question. Doing nothing is pretty bad. So short of doing nothing, I joke, but you get people who will put masking tape on things and say, this is who I want to get this, or who will leave some informal document with handwritten notes about who gets what. This account goes there. Randy's asking me, how busy are you? I'm really busy. What are you doing? Litigation. I'm in court all the time, and it's people fight, and clients will say, well, my family, everybody gets along. You know what? When the money on the table, things can go sideways, and the best thing you can do in an estate plan is have it clarified so that you've said it, so it doesn't become a source of tension. I say to people, if you say little Joey, oops.
We have run out of time. Doug Chalgian, Randy Dickinson, thanks again for joining us. We could use a whole lot more time, couldn't we?
Certainly could.
Want to thank you both for coming in tonight. Thank the phone volunteers that have answered all of your questions. Thank you for tuning in this evening. You've been watching Ask the Estate Planners on CMU Public Television. Next week is Ask the Veterinarians. Same time, same place. We'll see you next week. Thanks again.
Support comes from Smart Investing at Your Library, a partnership between the Genesee District Library, FINRA Investor Education Foundation, and the American Library Association. The mission is to provide the public with knowledge, skills, and tools necessary for financial success throughout life. More information online at thegdl.org's Dollars and Cents Cafe.